Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice Beverly Canoni, now sitting in the Dedham Superior Court within and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth from this good court. Thank you. You may be seated. Court now in session. Good morning, Your Honor.
22-117, the Commonwealth versus Karen Reed.
Okay, good morning, counsel. Good morning, Ms. Reed.
Good morning, jurors. Thank you for getting here promptly. I do have those 3 questions for you. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. With that, Mr. Fullman, I'm going to send you all back out.
All rise for the court, please. Jurors, follow me.
Thank you.
You are muted. You are unmuted.
Thank you. Be seated, court session.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right, so counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you. Ms. Giannetti, I'll hear you.
Your Honor, I would disagree with Mr. Lowry's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion,
Jim.
and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay. All right, so you all know that it is within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I'm going to send them back out. We'll bring them in and we'll do that now.
All rise to the court, please. Jurors entering. Court is back in session. You may be seated.
Right. So, jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. So, or continue your deliberations. All right? So I'm sending you back out.
All rise for the court, please. Jurors, follow me, please.
Thank you. Be seated. Court is still in session.
All right, so the note has been marked for identification, and we'll see you all either at 3:30 or when you get a phone call.
Court, all rise.
Triple B for identification.
Triple B. Thank you.
You are muted.
What's up, STS Nation? Get my headset on here. How are you all doing? We're about to be joined momentarily by retired Mass State Trooper Todd McGee. The breaking news right now, you see the scrolling. Happy Friday. You see the scroll crawling. It's hard to say. At the bottom of your screen, we got word that there was a jury question a few moments ago, and it wasn't really a question. It was a statement, which is we, the jury pool, the jurors, are deadlocked. We cannot come to a verdict. We cannot come to a conclusion about what happened here. And then both sides argued. The Commonwealth saying, look, you've got to keep deliberating here. This is their duty. They've only been deliberating. This is the third full day of deliberations. They began deliberating, I want to say, Tuesday afternoon. And Judge Beverly Cannoni directed them to go back into the deliberations room and continue to try to deliberate. The question is now, since they are deadlocked, how are they deadlocked? We have no idea. Jersey Girl is correct. The jury used strong words, hoping not to have to go back. This is what is possibly the beginning of a hung jury, meaning that they can't come to a decision about what happened here, which is interesting. Because that means one side's not fully buying the cover-up / conspiracy, and the other side is not buying that Karen hit John O'Keefe. And we don't know what the breakdown is here in terms of who is saying what. We are joined now by Todd McGee, who's much smarter than I am. Todd, what do you make of this? We got a jury question. It wasn't a question at all. It was a statement that we are deadlocked and we can't come to a conclusion about what happened here. How surprised or not are you by this?
Certainly one of the scenarios for an outcome in this trial. And I'm envisioning you've got 12 jurors that have bought into both sides. Prosecution taking weight of the utterances mentioned by Karen Reed, statements by the EMTs, those early responders in the discovery of John O'Keefe's body. And then you probably have the other half that are buying into the defense's position of there was no vehicle that struck John O'Keefe's body. And so therefore they cannot convict based on that evidence that was produced by the science evidence that was produced by the expert witness called by Jackson and Yannetti. So certainly outcomes that were part of the scenario. A mistrial means they're going to go through this all over again. And so could be problematic. But again, we'll have to address those issues if that is the actual end result in a mistrial.
Yeah, and Todd, we don't know the breakdown right now. We don't know, as Jay Bones here says, it could be one person that they can't persuade to the whatever side it is. It could be 11. It could be 4 and 8. Any multiple of 12. Isn't that right, Todd McGee?
Absolutely, and there lies our democracy. There lies our criminal justice system, where again you only need one person to hold out, and it sets off all these other different possibilities. So interesting that the persuasive closing arguments did not move a unanimous vote one way or another. So one could say that prosecution and defense both did their jobs, but at this point, the evidence that was introduced into the court case, the evidence that the jurors have to decide on a verdict, was not enough to get a unanimous vote.
Hmm. What's interesting, someone here, and I just passed right by it, said they predict the deadlock goes across gender lines, meaning the women are all voting one way, the men an other way. I'd be fascinated to know that. I think that would be quite interesting, but also pretty unlikely. What about that, Todd McGee?
So, the sentiment of the juries, whether it's based in gender, sometimes people identify with the defendant, and maybe there's a sense of connection, emotional connection with what the defendant is going through. So again, it's hard to tell, right? We hear from our legal experts. It's hard to get in the mind of the jurors. But with that said, it's fascinating to understand or try to understand what they're processing. What are they? What is that conversation like within that deliberation room? What are they processing? They ask a team search on the evidence, and that I'm not thinking more about that. I'm not surprised that that was not entered into evidence, because if you can remember, Canton police released the crime scene after within 3 hours of discovery of John O'Keefe's body. So did the judge determine after we like to call crime scenes sterile? That's the best time to search for evidence. That's the best time to be able to collect eyewitness accounts while you have an established crime scene. The crime scene was lifted. Now you have a unsterile environment. Is that why that evidence was not introduced? The evidence that was collected by the team during their search on the property, as described by the lieutenant in charge of the unit, you had CERT team members standing shoulder to shoulder, walking across that lawn, looking for evidence of any type, whether it was blood, whether it was tails, plastic tail ends, whether it was glass, whatever was there to be gleaned in documented, photoed, bag tagged, and transported, that was not entered into evidence. So that was certainly probably a determining factor for some of those jurors that needed that persuasive bit of evidence to move them to one side or another.
And Todd, I've heard mixed things from different attorneys, both prosecutors and criminal defense attorneys. If in fact this is a deadlock jury, in other words, a hung jury that cannot come to a decision, what do you think are the chances that the Commonwealth would retry this case?
Great question. There's been a lot of time, money, resources spent on this case. If they go ahead and retry it, I would anticipate there would be a different prosecutor, that Lally would not be the prosecutor. I also would expect a different strategy, or a nuance or a shift from the existing strategy. So again, these resources, also keep in mind that the investigation from the federal government, that FBI investigation is still at play. Those early depositions that happened 2 years ago from the witnesses, those are still in play. So you can retry the case, but not a lot of things are going to change.
We're joined by Rob D'Amico, retired FBI agent, and former member, decorated member of the military. Rob D'Amico, I know you're only able to hop on for a short time here. Appreciate you being here. What do you make of the fact that the jury on day 4, the third full day deliberations, appears to be deadlocked? Is it a surprise to you?
It's not. When I saw that they didn't come to that quick verdict, like the first day, I had a feeling there's someone holding out on, not sure what side. But when you look at all the comments that I see on your pages, especially the ones I'm on that I go back and read, it is the really strong opinions on each side that they have on the juries. Like, people just either believe one thing or another, and they believe it very soundly. And like your guest was saying, like, I am surprised with the closing arguments. I do think the prosecution had a decent closing argument. compared to everything I'd seen before. I don't think it was as good as the defenses. I think the defenses was very professional and done right on time. And you had mentioned that it might have been too slick for some folks, but right now someone has this just gut feeling that they're stuck on. And I think this one they may have said, "Hey, this is it. We can't do it." And the fact that the judge sent him back, not letting him go, may get to that point where they go back and forth. But I always say, like, hey, if you really think someone's guilty, you really think someone's not guilty, after 5 days of going back and forth, what do you really think is going to talk that person to the other side? Because if I thought she was not guilty and I had this, I'm not going to send a person to jail because I'm going to get talked into something after 4 or 5 days. And I think it's the same on the other side. Like, if I think she's really guilty, I don't want her to go free. So I think they may be stuck for this hung jury. And like I said, the longer the time went on from that first time, I think this was the natural thing. But it didn't surprise me. Like I said, the opinions were so crazy on the comments. Like, if you can't believe she's innocent, she's being set up, you're dumb. And it was the other way around. If you think she didn't hit him and kill him or whatever, you're dumb. And I think that's probably in the jury room.
Yeah, and Todd, just going back to what we were talking about a second ago, we don't know the breakdown. So I think it's obviously easier if we're talking about like moving an inert object or swaying jurors. It's going to be a lot easier to sway one holdout than, let's say, if they're split down the middle at 6 and 6, and we don't know how they're split at this point. Just to let you know what the Judge Beverly Cannoni, just a few minutes ago, if you're joining us, the jury came in with a question that was a statement, actually, saying that they are hopelessly deadlocked on the 4th day and 3rd full day of deliberations. At that point, the lawyers got up and ADA Lally said they've got to deliberate longer. It hasn't been a long time. And according to both criminal defense attorneys and prosecutors I have talked to, they said the same thing, that they would have to continue to deliberate into next week. And ultimately, that is what the judge told them. She said, and I quote here, Judge Beverly Cannoni, "We all know how hard you've been working. Lunch is coming soon," and basically shooed them back off to the deliberations room. Alan Jackson spoke to reporters. He simply said, "It's how deliberations work." Rob D'Amico, to you, this is a slick Los Angeles attorney, the best of the best, the cream of the crop, Alan Jackson. Notwithstanding a whole ton of controversy about whether a photo of him with Karen Reed out there last night is real or no, not real. There's no way for us to prove that. That's been all the talk on Twitter today. And, we can speculate on that during our 4 o'clock show if anybody wants to. But beyond just being what I thought was a very slick closing, Rob D'Amico, from day one, they've gone all in on the frame job, on the fact David Yannetti coming out in openings and saying Karen Reed was framed. And then in the closings by Alan Jackson, he was naming names and telling you exactly how this cover-up / conspiracy worked. Was that potentially a fatal flaw for him now in retrospect? And it's easy to Monday morning quarterback, even though it's Friday here. But should they have just poked all these holes surrounding reasonable doubt? Because there's a mountain of reasonable doubt. And I'm wondering, the long-winded question here is, did some jury members just not believe the cover-up? And that's what's throwing them off.
We talked about that on the first show I did with you on this one. I thought that was an oversell, that all this happened. And I look at it now, and like I said, those witnesses for the defense, I think they were lying about stuff. I don't know exactly what they were lying about, like the butt dial and all that was just so crazy. Mm-hmm. But to go in and say that this is the exact thing that happened, we talked about, like, well, it's not the defense's objective to prove that. It's just that the case what was poorly done, You have people lying. I don't know exactly why, but something's wrong here. Something's wrong here. And you can't convict if you don't have, beyond a reasonable doubt. And I think that was the way to go. I remember reading some of the comments like, oh, but the FBI has this investigation proving she didn't get hit by a car. No, they had two expert witnesses saying that it wasn't that smoking gun that said this is exactly what happened. And I think some people have a really tough time to put all that together, saying all these people are involved in conspiracy. And I don't think that exactly what happened. I had self-doubt. I personally could not have convicted her on what I saw. Do I know exactly what happened? I don't. There was no solid thing that came in. I think the defense attorney experts were a bit better than the troopers. But there's people out there, again, that are so strong on it. And I think they went over the top saying, this is exactly what happened, instead of saying, you can't convict because their case is not strong enough to put someone in jail for that long. So I do think that is what happened.
For those who are just joining the chat, and the numbers going up as we're talking here, so people are just joining. The jury is at this point hopelessly deadlocked. They said that there's a question for the judge, but the question was a statement, which was exactly that. We can't come to a conclusion. So Judge Beverly Cannoni did what I think any judge would do this relatively early on, with 3 full days of deliberations into their 4th day here. And said basically go back to the deliberations room. It is lunchtime. There's some factors here. One of them is it's a Friday, and Todd McGee, jurors are notoriously anxious to be done with their job. The weekend's coming. Not only is the weekend coming, but obviously next week is the 4th of July weekend, which is hard to believe. Is this going to be a factor? The fact that it's a Friday, are they going to, I don't know, have an easier time convincing whoever the holdouts are, whatever the number is, to be swayed? Or is that not a factor at all? What do you think?
No, I don't think it's going to be a factor. As Rob nailed in several points, and if you're in that position, either to convict or not convict, and that's you're just holding out on that, and that's your conviction. I don't think a Friday calendar issue is going to sway those jurors or juror that might be considered the holdout. But two other things that Rob mentioned, I think worth piggybacking on. The first was the aspect of there's no smoking gun, right? This case didn't have that element and that aspect to it. And, we have to understand, over 70 witnesses called, the amount of circumstantial evidence that was introduced, the amount of physical evidence, that was there, the amount of expert witnesses that testified in this case. That's a lot to process. And so if certain things, meaning evidence, was not introduced for one reason or another, that the judge excluded certain or found certain evidence inadmissible, some of that evidence the jurors were looking for to help sway their opinion or sway their verdict. So I think it's important that we kind of take a step back, clearly understand all that's not just what's at stake, because we understand everyone's looking for justice for John O'Keefe, but the process, right? We have to understand the process. We have the luxury to be Monday morning quarterbacks on a Friday. We have the luxury to be able to talk and dialogue by the minute, if we so desire, to share our opinions professionally, based on our professional lives. The jurors don't have that ability, so we really have to take a step back and let the process play out.
Yeah, I think Todd just mentioned one of the biggest things, and one of your commenters had said it. The jurors weren't supposed to go back and talk about this case until the end, and we did it every day, comparing a witness to this and that, where, oh yeah, I didn't even see it that way. So the jurors in their head every day have to self-evaluate what they're seeing, which is a monumental task, without being able to talk to other people that seen it. And your show and all the other ones on there, we get to talk about it every day. And I might have saw something, and then we talked. I'm like, oh yeah, I didn't even realize that. They did not have that. They were not allowed to talk about the case until they got in a room. So it is a bigger task than what we had, because we could sit and talk about it and say, oh yeah, I didn't see that. I noticed that. They had to go in cold. So I do think that's a big point of it.
By the way,
Rob,
go ahead,
even
Todd.
with the luxury of these, even with the luxury of these podcast platforms, you get to hear that public safety perspective. You get to hear that lawyerly perspective, and also from the lawyer's perspective, you hear the prosecution angle as well as the defense angle, right? So we've really had a very a vantage point, to your point again, about what the jurors have versus we on the outside here.
Leo Wren rightfully pointing out, great points, Todd. Rob D'Amico, to you. So the minute the lawyers heard that this jury was deadlocked, the attorneys for both the Commonwealth, Adam Lally, and the defense attorney, they got up and made their arguments. ADA Lally, very opposed to allowing a hung jury at this hour. Meanwhile, the defense seemed okay with it, almost like they wanted it. What's the thinking there, Rob D'Amico?
I think the defense is thinking that the state's not going to want to put the same case on. I think we talked about some of the stuff about overcharging and other things, and the public outcry and things. So I think the defense thinks if they get a hung jury, this may not go to trial again, or if it does, it's not going to have the second degree murder in it. And I think that's seeing it. And I think the prosecution does not want to do this again. Like that, like they want.
Yeah, I'm sorry. I didn't mean to cut you off there, but I've asked a bunch of attorneys what their consensus is, and I'm not saying they're right. But they would poll the jurors and see where they are in terms of who is, voting guilty, not guilty, etc., and then decide if they would charge again. So I just feel like either side, to not have an answer at this point is obviously discouraging. But from the defense perspective, they could say, look, they couldn't come to a conclusion. I don't think it's an ideal scenario, but then it's like what Rob said, can they then move forward to charge her again? Just imagine the people of Canton and Dedham, Mass, and around Boston, if we had to do this all over again.
Joel,
it would be unbelievable. Go ahead, Todd.
Here's a thought on that lesser charge. One of the elements is there's enough evidence to show operation. There's enough evidence to show that there was drinking during the course of the evening. But here's a missing piece. They don't have her blood alcohol. And the blood alcohol of 0.08 here in Massachusetts is where you're deemed as an adult over 21 operating a motor vehicle. 0.08 is the factor, is the threshold. But they don't have that evidence. This isn't an OUI case, so I'm wondering, and again, this is an attorney question. Without that blood alcohol, can they actually bring a charge of? Can they actually convict on that charge? It's a missing element.
Speaking of that, and that's a great point. There's different charges here, different counts. Rob D'Amico, how do we know? Are they hung on the second degree murder? Are they hung on all three? Are they hung on the involuntary manslaughter? Or do we just not know?
We just don't know. And again, polling the jurors to figure all that out. Personally, and again, this goes to personally, and everyone's going to bash me. I'm seeing this. That's the thing on comments.
Welcome to the club, Rob.
I think the second degree murder, like that's not what they're hung up on. I just don't see that being the case. I think it may be the person that's a holdout or whatever is holding out on one of the lesser charges, and I think the other ones are saying not at all. But I don't think it's the second degree murder one. I don't understand how any juror can, with the case that was put together in the investigation, the intent and everything else, that with the elements of the charge could say that. But hey, this is a personal opinion, and like everyone will bash me that I don't follow the trial or anything like that you're getting to. But I don't see how they're stuck on second-degree murder. I think it's a lesser one who's ever stuck on it.
Josh Ritter, prosecutor of the year from Los Angeles, host of Courtroom Confidential, and a great criminal defense attorney in his own right. Right now, I'm just looking at video. The scene is much different out right now. It looks like this actually might be from this morning. Karen Reed, though, looking much more glum than she typically looks. Josh Ritter, being the mensch that he is, hopping on while he's got a busy day out in LA. Josh,
Now,
your reaction?
What I miss? I'm just
you-
hopping on to say hi. Am I missing something?
Hey, I got to jump off, Joel.
Okay, Rob, thank you so much. One comes in, one goes. Have a great day, Rob. Hey, Rob, don't let the trolls bother you. Josh Ritter. So the jury obviously had a question, but the question was a statement. And Sky Lazar, look at this. People are coming in left and right. So Ritter, it wasn't a question, it was a statement, and it was, we are hopelessly deadlocked on day 4, but day 3 of full deliberations. Your perspective as both a former prosecutor and an attorney, criminal defense attorney, does this surprise you?
Well, do we know the breakdown? The judge never asked for that, right?
Nope, we do not. So we don't know
Yeah.
if it's 6 and 6. We don't know if it's 11 and 1. We don't know if it's for guilty or not guilty. We know nothing as far as I know.
I mean, I'll say this. First of all, in a case like this, no, I'm not surprised. I mean, you saw moments of very powerful persuasion from both sides. I know that the prosecution has received a lot of criticism for how the investigation was done, and the advocacy on the part of Lally and everything else. But end of the day, you still have witnesses who are saying that the words out of her mouth were, "I hit him, I hit him, I hit him," and you still got taillight fragments all over the crime scene, which relate back to her vehicle. So to say that there's zero evidence to prove a case here for the prosecution, I think is a real stretch of what it was. But the defense, for their part, did an incredible job of really poking a lot of holes and bringing up some questions that were either difficult to answer or not answered at all by the prosecution. So the fact that we've been having these discussions for so long, and every time somebody asks me, where do you come out on this, I don't have a quick answer to it. I think the jurors are feeling the same way. And so you've got some very, probably reasonably minded folks back there who just can't come to an agreement on it. The one thing, though, and Sky, correct me if I'm wrong on this, but to me, what it indicates, though, is that they are hung because they cannot get, there are lesser includeds here.
Right.
And my understanding is they cannot get to the lesser includeds unless they have reached a verdict on the greater counts, meaning they either have to acquit or convict on the greater. So let's assume that they didn't convict. They would have to acquit on the greater to even be considering the lessers if that's what they're hung on, are their lessers. So to me, again, I know I'm rambling here, but that means that they're hung on the greater count, that they have not reached a verdict on second-degree murder in this case, and they've not even then taken the additional steps to go to the other ones. Because I feel like if they had, they would have said, we've reached some verdicts, but not on others, and we're hung on others. But the fact to say we are hopelessly hung, to me, means they didn't even get past step go.
Which is a really interesting distinction there. So if I'm understanding Josh correctly, you've got the second-degree murder and then the involuntary manslaughter. And Josh is saying they just couldn't decide. They would have to decide on second degree. Is that right, Josh, before moving on?
That, I don't have the verdict form sitting in front of me, but the way it usually works with when you have lesser included is you are not allowed to start to get to those lesser included counts unless you have reached a consensus on the greater count, meaning a conviction or an acquittal. Then you move on. I mean, obviously, if you reach a conviction, you don't move on because that's all you have to do. But they have to have acquitted her on the greater counts before they move on to the lesser ones. So to me, they're hung on everything.
Very interesting. Sky Lazaro, a high-profile criminal defense attorney out of the great state of Utah, joining us. What do you make of this, Sky? Your bird's eye view. We're getting word, obviously, just a few moments ago that the jury is deadlocked, the judge ordering them back into the deliberations room. What do you think?
I tend to agree with Josh. I think and we talked about this the other night, and we were given predictions, and I mean, I could have seen this case going either way. I think it's easy to drink your own Kool-Aid when you're trying cases like this, because you have to believe in your case to be an effective trial lawyer. But looking at this kind of from an outside view, I agree with Josh. I think they're probably hung up on the first count because they would have or should have been instructed that you need to make a decision on count one before you even start to consider any of the lesser included. So if they're just saying they're hopelessly deadlocked, I kind of read that the same way, that they're hung up on count one and can't come to a decision. I think it's probably rightfully so. Judges typically do this, where a jury will come in and say, "Hey, look, we're stuck," and judges send them back in and say, "Keep trying." They usually read them an additional instruction that's appropriate under the case law, and send them back in and tell them you don't get to just give up yet.
Wish you had people on your panel that are neutral. I don't think any of these panel members have a dog in the fight here. So I always get that comment. I'm Prosecutors Podcast, one podcast of the year last year. And here's Mark Betterow joining us. Mark, before I get to this tweet, thank you for joining us. Mark Betterow has been a very well-known face and name in this trial, leaning heavily toward the defense. Are you surprised, Mark Betterow, that we are seeing a deadlock jury at this point?
A little bit. I mean, it happens. It is a murder case where it went on for months with 70 something witnesses, like the judge was saying, hundreds and hundreds of exhibits. So, in that sense, I don't think it's that abnormal. I mean, personally, I thought the evidence was pretty weak. So it's surprising, but ultimately it's the 12 people in the room. You don't know what they're thinking, what they're analyzing. I suppose she could have given an Allen charge. Maybe I would have done that on a Friday, and rather than just kind of say nothing and say go back, which I don't think will accomplish much with the jury who just said we don't really want to deliberate anymore. So I guess you'll have to wait and see. But it's a little surprising to me personally. But if you take a step back from this case and just say it's a complicated murder case with all that evidence, it doesn't shock me.
Mark, sorry to jump in, but Mark, is that I hadn't actually seen that part. Is that true that she didn't give an Allen charge? She just kind of said to go to lunch, come back and think about it again?
Yeah. I mean, she punted, and I was sitting there watching it, just kind of shaking my head. So, the note basically said we're deadlocked in so many words. The prosecutor did not want the Allen charge. The defense did. In her discretion, she said, I'm not giving it, and basically just said, take lunch, rest up, and go back. And with no pep speech, no nothing. I thought it was pointless.
Yeah. Mark, forgive me if I misunderstood this, because I was watching and running to the studio at the same time. But it was my understanding that Adam Lally got up right after they said that they were deadlocked. And I apologize, I'm doing two things at once related to this show. But Adam Lally got up and said they can't stop deliberating. It's too early in deliberations. But then David Yannetti on the defense side seemed to be okay with a hung jury. It doesn't seem like a best case outcome, but is the thinking there that they will not retry this case and the defendant gets off and they'll take it any which way they can?
I mean, you would say 99% of the time that a mistrial favors the defense. I mean, if there were a mistrial here, she's not going to jail, she's not getting convicted, and you deal with whatever comes next down the line. But I would think, yes, that at this point, if there were a mistrial, is it a guarantee that they would try her again? Normally, I would say a murder case, or at least some form of homicide case of a police officer, you would say, how do you not retry that? But then this case is kind of not the ordinary case. I think there would be political questions. I mean, there's a lot of criticism of the DA's office and the state police. Are they going to use Michael Proctor again? I mean, politically, can you do that? Are you going to use this Buchanan again, who his testimony, he's got problems, I think, with the inverted video and other things that he did. I'm not sure I'd want to testify if I were him again.
Are you bringing back all of these Alberts and McCabe's? I don't know. I mean, do you do that? The other thing is, if there is a mistrial, if I'm the defense, I'm trying to get the hell out of Norfolk County with a change of venue at this point, to get as far away from Canton as possible, possibly to get away from this judge. Although, you know, I guess it's possible the judge could travel with them, and the defense would get what, 60 something sworn transcripts of prosecution witnesses. I mean, so at least if there were a retrial, it does tend to favor the defense from a, you know, form. They don't want that. But on the other hand, they want her to be publicly innocent, you know, which is not the business of the courtroom, of course, not guilty or guilty. But if it's a mistrial and ultimately they don't try her, she wins in that she's free, but you don't get that feeling of, you know, I'm innocent from a lot of segments of the public either. So
Mark,
there are a lot of questions. Go ahead, Todd. Go ahead.
A thought to throw out there for the other panelists as well, Sky and Josh. So let's just say there's a hung jury, there's a mistrial, the state opts to retry the case. A couple of considerations that are still out there. One is the Proctor factor. I don't think he was removed from the office because of the optics. If he was transferred out of the detective unit, that would have been a huge win for Yannetti and Jackson. The second aspect is the federal investigation. That's still hanging out there. So those don't go away because there's a mistrial.
No, you know, I think everybody's right to point out that it when you're considering a mistrial, usually you're trying to decide as a prosecutor, you know, have we put on our best case? Is there anything that we could have done differently? Obviously, you pay attention to how the jury was split. That's going to guide you a lot. If it's split heavily in favor of a conviction, you might think, okay, we just had problems with jury selection. But in this case, I think it becomes far more of a political question. They want to know, what is the fallout going to be to our office if we try to go through this entire fiasco again? You know, you've got a politician who runs that office who's got to consider, how is this going to reflect upon me? But then I think they also are thinking to themselves, well, what excuse do we have to just walk away from this? And so my view is they might hand her some really weak plea just to say, we did justice, we have a conviction in relation to this case, you know, and have some sort of PR excuse to come to the public with. But I agree. I think for a bunch of reasons that really have nothing to do with whether or not they feel like she's responsible for this murder, it may play a role in whether or not they make a decision to retry her.
Sky Lazaro, Barb, who was in the chat, have been jotting down some of the questions. She wanted to know from you, does Judge Beverly Cannoni and or the attorneys on both sides, did they know the split in that jury room, or is it that no one except the people in there who know?
I didn't see what was said in court live, but my guess is whatever was communicated on the record is probably what they know, unless they had some sort of in-chambers meeting. If the jury just came back and said we're stuck, then that's probably all anybody knows, would be my guess.
Yeah, Joel, there's no way that they would know what the split is. I mean, it wouldn't be appropriate to put that out there. I mean, 11-1, could be 6-6. I mean, that's kind of the wild card in all this. You don't know. One other thing, just I wanted to add to what Todd said about other reasons not to try it. We had the whole federal thing looming in the background. There could be more TUI dumps coming, which could further help the defense. We don't know, but you know, you shouldn't assume that they opened their file and just dumped it on them the first time, but they obviously were willing to give them these really powerful experts, which is a pretty strong editorial statement about what they think about the case. And if there's other things that they have that they don't believe need to be held confidential for whatever they're looking at or not, those very much could be dumped as a further disclosure and mess up a possible second trial too.
Mark, let me ask you, because I know you were up there and you've talked to Alan Jackson. In retrospect now, should he have gone harder at the mountain of reasonable doubt? Is it possible, and it's obviously easy to Monday morning quarterback, that he went too deep on the so-called cover-up, and that's what's got some people concerned in that jury room?
Maybe. Look, I thought his summation was excellent, but when you have an hour limit, you certainly have to allocate properly in a trial this long. And what I had said elsewhere, I was surprised. I thought that what he would do would lead with the ARCA stuff, because the science trumps everything. And if there's no car accident, there's no crime. And if there's no crime and the taillight could not have exploded in the way that the police claim, then that's a good segue into the sketchy part of the defense, which is then how did the taillight get there if it couldn't have been from the car accident? So I would have thought that if you start with the ARCA stuff, everything else flows from that. And the jury's already heard that, wow, it's like per se reasonable doubt. If there's no car accident, there's no crime, and the science says there's no crime. And then kind of weave in some of the other stuff. So maybe it was a little heavy on the Alberts and that sort of thing. On the other hand, I thought it was very persuasive, but I think the point's a fair one. Obviously it's 4 days into it, so something's bothering someone.
Yeah, I don't think there's any way to really be sure, but people are reading the tea leaves here. Bossy Texas chick is one. The way they worded it didn't sound like it was a 10-2 or 11-1. It sounded like it was split right down the middle. There is no way to know, and that's why they said they were exhausted. But it's definitely possible. By the way, these best guests all have real jobs, unlike me. So if you guys have to hop off at any point, please, I don't want to keep anyone from their billable hours, Todd McGee included, who's got a consulting firm. But the Prosecutors Podcast, they won Best Podcast, and Brett and Alice went to Harvard and Yale, who host the show, so they're pretty smart eggs. But this is a tweet for them. I want to read it out loud. It's a long tweet. I just want to get Josh's reaction, and then Mark and Sky and Todd. They write in the tweet, with the jury indicating they are hung after several days, it's unlikely the judge's request that they go back and think some more will make a difference. Then it'll be time for the Allen, or TUI as it is called in Massachusetts, the Allen charge, sometimes called the dynamite charge. It's a very aggressive instruction from the judge, laying out how expensive and time-consuming the trial has been and telling the jury to get back in there and make a decision. It's controversial and usually effective, but I don't see it working here. If they are split on all counts, then at least one person thinks Reed is a murderer, and at least one thinks she didn't even hit John. That's a big gulf to bridge. Maybe they can, but this now feels like we're headed to either some sort of settlement or a new trial. Which one will depend on the number of votes on each side. Josh Ritter, help us break that down. Do you agree? Is the Allen charge coming? Is it inevitable?
I think it is coming. I think it'll probably happen, in the afternoon, if the judge brings them back and says, have you made any progress? I think, we're assuming a couple of things, that that they've been hung for days. We don't know. It could be that they were considering all the evidence for a couple of days, and then when they got down to actually trying to find out where everybody fell on this, they realized that they were hung. I think it also assumes too that they're hung in a way that is not that is more evenly split. If they're hung, heavily favoring one side, then an Allen instruction may go a long way, because if there's two jurors or one juror that's a holdout and they get that instruction from the judge, and I think that characterization of it is correct, that it's strong language. It's basically saying reconsider where you stand. If you are for some reason need to take a step back and reconsider your own position on this thing, then we encourage you to do so and have an open mind. And there's going to be 10 faces that turn towards those two who are the holdouts and say, hey, where are we at on this? Convince us why you feel so differently than the rest of us do. And that may push those folks over the edge. But, again, we're on a Friday. It's a holiday week coming up. I think there's this kind of internal pressure for everybody to wrap this thing up. And I imagine that if she will She will instruct them on that today. But I also could see in a case like this, the judge doesn't want to retry this thing either. And she wants this all kind of wrapped up in some sort of way. She likely does not want to see any of these folks back in her courtroom anytime soon either. And I could easily see her saying, I'm going to give you the weekend to think about it. And we'll revisit this on Monday. Go home, sleep on it. And if you still feel as strongly as you do, then we'll talk about what to do next.
Sky Lazaro, there was a plea deal at one point on the table that Karen Reed obviously didn't take. Do you see any scenario now where they come to some sort of plea agreement where she obviously is steadfast that she did not commit this crime, but just to, get things over and done with? Do you see any scenario where maybe she would take a 16-month or some sort of other potential plea deal here?
Not knowing her personality or what those communications were like, I do not see her taking anything related to a manslaughter or death type charge. I could potentially, I think plea deals are always a possibility. She doesn't want to do this again. It doesn't, who knows if they're out of money to be able to pay for a new trial. There's a lot of things I think that factor in. She might just be emotionally exhausted and want to put it behind her. Like Josh said, if they come in with just some sort of offer, I don't know, reckless driving, leaving the scene of an accident, just something to get some sort of conviction. I think people at the end of trials, when faced with the potential of having to do it again, would take an offer like that. But it's hard to say. I don't necessarily seeing her. I don't see her taking anything related to a manslaughter or murder charge.
Jay is laughing his you-know-what off. Plea agreement. Joel, the FBI said she didn't kill him. Mark Betterow, any chance in hell she takes even some sort of small plea like what Sky was talking on a much smaller charge, just so the Commonwealth can say they got her and move on from this?
I doubt it. And I go back to the whole ARCA thing, and maybe they didn't present it in a way that they could have. I don't know. But that testimony was basically saying that it was scientifically impossible that the accident could have happened the way they allege. Now, would another round of jurors, perhaps, if they fine tune that and emphasize that more, help? I don't know. But, the Allen charge that you read us, that description, I kind of take issue with that. I think that's overstating what it is. And that if that charge were given in the way it was described in the tweet and it resulted in a conviction, you would have a very strong appellate issue, because jurors in an Allen charge are not told this is expensive and important and you need to get back in there and reach a decision. They get urged to, be open-minded. It's important. If you can reach a decision, you should try to. You don't have to cave in. You should listen to other people and not, give up your values, but you should consider other positions and try. And it is kind of a semi-aggressive thing, but they wouldn't be told you literally have to do something. And if that charge was given in that way and resulted in a conviction, I think you'd have a very serious appellate issue.
Todd McGee, you're the voice of reason, as always, calm and level-headed. This is obvious speculation, but what do you think the demeanor is in that deliberations room, if you had to guess right now? Do you think they're fighting with each other? Do you think it's civil? Do you think because things can get heated in a jury deliberation room? What do you think's going on in there? And I guess it could get heated more so if no one is agreeing.
Without a doubt, it's tense. It's got to be tense. Again, for all reasons, whether it's a Friday afternoon or whether it's a we've been here too long or whatever emotion is attached. I'm thinking certainly tense. Thinking about the decision on where to land for guilty or innocent, let's take off the last two witnesses brought by the defense, the expert reconstructionist. Let's talk a moment about Trooper Paul's testimony. The only thing worse than his testimony was his theory. It just didn't make sense. It wasn't plausible. And for the state to call Trooper Paul as a witness, at best, he's an end user practitioner. of whatever resources and tools that are utilized within that unit to measure his credentials up against the defense experts. It's night and day. And say that you have an associate's degree and you've taken a couple of courses in accident reconstruction does not make you an expert.
Sky Lazaro, you're the only woman on the panel, and you guys are better observers of human nature than us men. So just getting this tweet from Christina Rex, who's a best guest and also a WBZ reporter. She's been in the courtroom this entire time, I think with the exception of 2 days. And then Ritter, I'm coming to you with this comment next. That's on the screen right here. But she says, Sky Lazaro, and I quote, "Some jurors just looked tired coming in. A couple were smirking. That's the only way I can think to describe it. A really awkward smile." What does that tell you? I mean, you've tried to read juries so many times in your life, trying to figure out, is it even a possibility to try to read a juror? And by the way, a quick tease ahead, 4:00 today, we've got Richard Gabriel. He's probably the preeminent jury consultant in the country. Worked on the OJ case, worked on the Phil Spector case, and a million other high-profile cases, and he knows jurors. But what about this? That they looked incredibly tired, and a couple are smirking. Sky.
I mean, I think it's completely understandable that everybody's exhausted. They've been at this for days. It's mentally exhausting. It's emotionally exhausting. So that, I think, is to be expected. The smirking, you know, if they're smirking, you hope they're leaning your way, because they're probably the ones in there putting the full court pressure on whoever's, you know, holding out. So it's hard to say what the smirks mean. People's personalities are different. I don't know if that's a good sign, but I don't know for who. So, you know, it probably means that there's some strong personalities in there, and maybe they are hopeful they're going to get to go home. Maybe they're hopeful they're going to go back and push whoever's holding out into whatever position they're on.
I just got my lightning alert. So if I go blank, it's not because I'm upset about what's going on. It's because of Mother Nature. So I'm giving you advance warning here. But Josh Ritter, here's a comment. Jimmy McNutty, love him or hate him, and he's very pro Karen Reed's guilt. We'll make that abundantly clear. He's also been a trial watcher. But if it's a mistrial, Ritter, the judge gave definite leeway to flirt with the 1105 third-party culprit to open a door this trial. They didn't. Can the judge say no flirting with a 1105 next trial? Can you kind of break that down for us non-obsessive, compulsive trial watchers and or lawyers?
Yeah, this is getting a little bit into the weeds, but I like it. But there was a lot of discussion in pretrial in limine motions about whether or not they would be allowed to present this so-called third-party culprit defense. And the judge said her ruling was, "I'm not going to say no. I'll allow you to kind of cross-examine and see if you can't flesh out that issue, and then I'll make a decision based upon kind of how the trial develops," which, you know, I thought was fine. But then the opening statement of the defense was Karen Reed was framed. And I thought, okay, well, we're off to the races as far as any kind of third-party culprit liability discussion. Now, they didn't exactly identify who that person they felt it was. They identified a lot of potential suspects and presented those to the jurors. And so I don't quite know what the defense would do differently had the judge said, sure, you can have your third-party culprit argument, that they didn't already do. But to answer that question, sure, a judge can change things on the second time around based upon not exactly how things went the first time around, but just based upon, you know, a new evaluation of the case law or the arguments that are presented that second time around. I mean, not to, you know, do too much of a callback here, but we saw that famously in the Menendez trial. They had a trial. That trial hung on murder. They had a whole theory based upon, you know, they were victims of abuse at the hands of their father. And the second time around, the judge said, not letting you get into any of that, and basically gutted the defense's case. And that resulted in convictions across the board for them. So yeah, a second time around, a judge can reevaluate, and it's supposed to be based upon, the law and the arguments made that second time around, not just merely a judge trying to manufacture a conviction. But you're right. If we came back around, we could see a different case in front of us.
Mark Betterow from Brit K to you earlier in the chat. She wants to know from you, what, if any, strategy did Adam Lally have by specifically asking when they came back to say that they were deadlocked to not give the jurors any more instructions? What is the rationale behind that from a legal standpoint?
He just wants them to keep going and end this. And he probably thinks that he's in the game somehow, that they're stuck on something, whatever charge it may be. And if there's a chance that they can grab something, from their perspective, they ought to grab it. So why do anything if it's going in the way they perceive the case pretty well? I mean, again, I think a lot of people thought it would be a relatively quick verdict. Most people who felt that thought if that was the case, it'd be a defense one. It's going a little longer. I think usually most people would say the longer it goes, usually not this case, that it would favor the defense and an acquittal. I think this one is actually opposite, and that it seemed like a defense case, and the longer it goes, that there must be someone or someones who are held up on, some of the prosecution's evidence that they may be crediting. So from their perspective, I think they would just let it go. It's going well as best as they can see.
By the way, by my count, they're at about 18 hours on the nose with deliberations when they came in and spoke to the judge. Sky Lazar, then I'm getting back to Todd McGee. And again, I appreciate these best guests who are the best of the best being here. And I understand if you have to go at any point, you just hop off, give me a wave. But I appreciate you being here for the time that you can give us. Here's a tweet. I have no idea who this person is, Sky, but it just brings up a thought. This person tweets out, maybe if Alan Jackson had brought that play fight in the bar up more. That's the whole tweet. As a defense attorney, when this situation is going on, or a prosecutor, are you running through everything that happened in this trial over 9 weeks in your head saying, maybe I should have said this, maybe I should have said that, maybe I should have focused more on this? Is that what goes on? We all know I can tell you're kind of a free spirit, Sky Lazaro, not tense New York and Bostonians like Betterow and myself. But are you second guessing yourself?
I think every good trial lawyer does that. I think that's what keeps us in the fight and keeps us wanting to get better. Personally, I start doing it from the time I sit down after giving my closing statement. Things start popping in my head like, I didn't ask that question. I didn't say that. I missed this. I mean, I think it's one, human nature, but I just think trial lawyers are a little bit of a different breed, and we, want to get better and do better and do it right. And you never want to miss saying the one statement that might have swayed them the other way, even though you may never know what that is. So, I mean, I think we all do that. And I mean, I do it after trials for a period of time.
Yeah.
100%. I mean,
if Sky's doing it, then everyone's doing it. Todd McGee, one of the things that I'm personally concerned about, and I'm seeing some tweets that there's a counter protester or several right now to the free Karen, so-called free Karen readers. You're former Massachusetts State Police. Are you worried that there's going to be some, and I'm not trying to be hyperbolic here, but are you worried about some civil unrest? Things are getting a little heated outside that courtroom, even as we speak. What does the Massachusetts State Police need to do now? And I mean, the vitriol on Twitter, I can tell you that firsthand, having been told to jump off a ledge the other day, is really bad. Are you worried about this in person, though, at the courthouse?
Apparently, with anticipation of the verdict coming yesterday, the state police did deploy more resources at the courthouse. Today just seems that it's trumped whatever was happening yesterday. So I believe there has been more infrastructure put up, more gating, more fencing, more containment. And from there, you start putting in maybe some detective assets into the crowd as an intelligence piece. If this gets out of hand, it's going to be a much bigger issue. Typically at courthouses, right, the security is inside the courthouse. And then you have, police officers coming and going during the course of the day for their own specific trials and caseloads. But this is something that's unique, and it's kind of taking on a life of its own protest, like we saw with the George Floyd, after the George Floyd murders. So this is taking on a life of itself outside of the courtroom.
Nina Stanek, Josh Ritter, this one's for you. Does the defense agree to a hung jury because they want the FBI investigation to be completed until a new trial? Is there anything to that? I mean, is that a factor in what they are weighing right now?
I think the defense agrees to a hung jury because it's a win for them. I think that's how they view this. They if they are able to end this, the prosecution, in my view, put on the best case that they're ever going to put on. And as everybody's pointed out here, it's likely only going to get worse for them the second time around. Does getting worse for them include that FBI investigation? Probably so. I think they are thinking, they are going through the decision matrix the same way that the prosecution is on whether the prosecution really wants to go through all of this again. And they're thinking, walking away with an acquittal would be fantastic. The silver medal is a hung jury because their client is going, if this is a hung jury, their client's going to walk away free today. So that's mission is accomplished as far as they're concerned. Maybe not all that they came for, but absolutely the defense is pushing for a hung jury here and hoping that the judge, gives whatever instruction she needs to give before the end of this day, and they can conclude this before the weekend. Because they did a masterful job, I think, in certainly convincing some of those jurors that she's not guilty.
How about the flip side, Sky Lazaro? Would this, I mean, in reading all the commentary on this, it seemed like the odds were so stacked against the Commonwealth. So does it go both ways? Would a hung jury here be a victory in essence for the Commonwealth?
I mean, I think the same thing is true. It's better than an acquittal for them. They at least get the opportunity to reassess whether they're doing it again. But I agree with Josh. I don't think their case gets better. I think it gets worse. I think if the Department of Justice puts out any sort of report about their investigative tactics or techniques or any of the way they're doing things, they're just going to get beat up worse than they already did.
From Tina, and you see, we are in fact a global show, and this case is garnering attention around the world, including hello from Dubai. I came into this case knowing nothing, and 9 weeks later, I'm still not convinced by the Commonwealth. It's obvious that some of the jurors are not thinking the same way as Tina T. Chris here, kind of echoing what we were saying earlier. Jackson is amazing, but I would not have spoken so much about being framed, more about no evidence. And as I said, we discussed that a little bit earlier. Mark Betterow, to you, it is quite possible that one day you could be a college professor teaching law. I don't know where. You've got the background. What would you say to people right now who are frustrated on both sides? Tempers are running high, but simply from a American civic standpoint, from the way our justice system works, is it working the right way right now?
Well, I mean, there's a lot of circus outside the case that I would say is not working the right way. I mean, there's a lot of just nastiness about this particular case online that I've never seen in any other case. But as far as inside, I mean, the jury's deliberating. They're on day 4. They're struggling. They're still deliberating. I mean, it's working in that sense. And whatever they come out with, it is what it is. They've assessed the evidence and they either make a decision or they don't, if that's the case. And if they don't, then it goes back to the DA to figure out whether they're going to try it or not. That's the system. It's the only one we have. It's better than anywhere else, but it's not perfect. I mean, what can you do? It's people. I mean, if it's a hung jury, everyone's going to be pissed off. No one's going to be happy. DA doesn't want to retry it. The defense doesn't want to retry it. The public is screaming for an outcome. I mean, obviously, if you're Karen Reed or her family, that's a win. You walk out, as Josh said, that's good, but it's not over necessarily. Probably not, at least for some period of time. So it's just the way the system is, and the idea of having to do this trial again is probably not anything that anyone wants to do. I mean, look at two of Karen Reed's lawyers live in Los Angeles and have been staying in a hotel in Massachusetts for months away from their families. Can you imagine going home and then saying, all right, come on back in a month or two or whenever if it gets retried, and say, let's do this again? I mean, it's just emotionally, it takes its toll on everyone. And if you're the prosecutor in this case, if they do retry the case, I have some good advice for the DA's office. Get them a trial partner, someone to help them out.
Yeah, 100%. I mean, look, everyone's, Lally is the target of so much criticism, but the guy did it single-handedly.
Very critical of his skill set and performance, but in all fairness, to have one guy handle a case like this, who's ever seen that? It's unbelievable.
Yeah, it's crazy. I'm looking at all the comments and looking at other things here. There's another Todd McGee. We're getting from a reporter, David Beanick. I'm sure I'm butchering the last name, WCVB, which is an ABC affiliate. He's in the courtroom. Todd, he says, as the jurors filed out of the courtroom, they hung their heads and looked discouraged. I mean, what does that tell you? Does that tell you it sounds like a group of people that just can't come to an agreement on this, no matter how much time they have?
Yeah, without a doubt. You've probably got a portion of the jurors that are ready to move on. You've got another portion that are hanging on to their conviction of how they feel. They're certainly at an impasse based on our conversation today, based on what's come back out of that deliberation room. Again, this is the process. This is not rare. This is not a unique situation to the Karen Reed trial. It's just a part of the process. And those of us on the outside, not having the liberty to be present and in the moment, in understanding the play-by-play and moment-by-moment nuances, we're all speculating as to some of the things we talked about earlier. Is it 1 holdout, or is it 6 holdout, or is it 11 holdout? So all these different factors are at play. What remains to be seen is, again, instruction from Judge Cannoni. What's going to happen? We're only at 1:30 Eastern time, so there's still a few more hours within the court day. Let's see how it plays out.
Yeah, they've been going till 4 every day, not much beyond that. I did think, I agree with Mark that overall Lally was kind of a snooze fest, but the closing I thought was fairly strong, mainly because he was using Karen Reed, who did not take the stand. He was using her own voice. But Josh Ritter, people in this chat are arguing, and Out of Time says that voicemail is proof how ugly and mean she became. John ended their relationship in front of the Alberts. Listen to her voicemail again. 12:41 a.m. is proof. I do think it was an effective tactic hearing her in that kind of crazed state of mind. Is that possibly what's got some of these people tied up? Because until then, didn't really get a sense one way or the other of her character. Hearing someone like that is so much different. Was that a factor or not at all?
No, I think so. I think it's very powerful evidence anytime you can hear words out of the defendant's own mouth, whether that's the defendant taking the stand, the defendant in a police interrogation, or recorded voicemails like this. They get like you said, a flavor for her character, an idea of what she was thinking at crucial points of this incident. And yes, the prosecution, though they don't have to prove motive, that was certainly something they needed to provide something to the jurors on this case. Why in the world would this woman, no criminal record whatsoever, commit a crime like this against the person that she was supposedly in love with? They have to give some sort of reason for jurors to wrap their heads around. now the voicemails do go on to have her, asking questions like, "Where are you? Why aren't you coming home?" And that was highlighted by the defense as her kind of desperate search for him because she didn't know where he was. So they kind of cut both ways. But absolutely, anytime I certainly know this as a prosecutor, anytime I could get anything that was a recorded statement coming out of the defendant's mouth, I'm likely going to use it. Even if that's jail phone calls where they're mildly talking about the case, because it gives the jurors some idea as to what's inside the defendant's mind.
He's been at this.
On that note, Joel, I gotta leave you. I gotta do my actual job.
I hear you. Have fun with that, but make sure you check out Courtroom Confidential. You're going to get analysis like this. Josh Ritter, Prosecutor of the Year in LA, and a very capable criminal defense attorney. Josh, thank you for being here. I appreciate it.
Very good to see you all. Take care, guys.
Take care.
See you, Josh.
Take care.
He's been at the center of the controversy, so I'm going to tell you what's going on with Turtle Boy, because there's some Turtle Boy news coming in as we speak. I'm going to read his quote, his tweet. "The fake victim has shown up with crusty panties in the buffer zone, which has forced me to leave because of the bogus order she got on me for lying about an assault. I'd like to go to the buffer zone to visit turtle riders, but she showed up and I'm ordered to leave." So he is there at the courthouse and cannot be there because he has got a stay away order. He went on to tweet to his minions here. Reminder, there is no way 12 people will ever unanimously agree that Karen Reed committed murder beyond a reasonable doubt. It's impossible for any honest person to believe. I have no idea what the jury is doing, but I do know that it's impossible to find 12 people who will all agree that she should go to jail for the rest of her life. Brother Counsel, you're the last person I want to put in the crosshairs of Turtle Boy, but I'm about to do it. Do you agree with him? Do you agree with him there that it's got to be the other way, that the majority of these jurors are convinced of her guilt, and it's very few who are saying not guilty, even though we have no way to know what the breakdown is?
Well, I know I'm Jewish, but I'm not a prophet, so I can't really tell you about that. But I feel strongly about this case. I've been watching it from day one, watched every minute of it. I've been probably one of the most subjective, I believe, watching this, taking all the evidence in, not jumping to any conclusions until I saw everything. And after everything was in, as you heard last night pretty clearly from me, I think any lawyer would say that there's certainly reasonable doubt here, and the verdict should be not guilty. That being said, I still don't believe that all 12 jurors are going to come back as not guilty, which is why I predicted that it's going to be a hung jury. So we're probably seeing that play out. We do know, and anyone who's been somewhat following this case or covering this case or posting about this case, and by the way, welcome to everyone here. Nice to meet you all.
Brother, this is Mark Federow, seasoned criminal defense attorney Todd McGee, former Massachusetts State Trooper Sky Lazaro, the Zen queen of criminal defense. Go ahead.
Yeah, well, maybe then I shouldn't speak in front of Sky, but
I don't know.
Yeah, I mean, anyone who's been following this case and covering this case knows that there's a very strong opinion that she's guilty. And they don't care about biomechanical engineers. They don't care about experts. They believe that the evidence shows clearly that she's guilty. And my guess would be there's at least one of those people sitting on the jurors. And to convince them out of their position has proved futile, at least for me. So all the negotiations and that I can, all that experience is not going to help me. It doesn't help me with these individuals. And I imagine that the people on the jury are having the same luck. So like I said, I assume it's going to remain a hung jury. I don't know what the count is, but I think that the more reasonable position here is that it's a not guilty. So it wouldn't surprise me if most people are not feeling not guilty, and then there's a few holdouts. But again, rant, speculation, and prophecy. So I'm going to. That's not my strong point.
Andy Logan. I'm not pulling the comment up because I want to get to this one. But Joel, you need to have my husband on. Longest sitting judge in Tennessee, 42 consecutive years. Andy, please have him email us, survivingthesurvivor at gmail.com, survivingthesurvivor@gmail.com. He sounds like best guest material to me. Todd McGee, retired Mass State Trooper. I think a few jurors are afraid to vote not guilty because of the town corruption. Very interesting question here. This, on the defense side, all surrounds a cover-up because of corruption and alleged, allegations that the Higgins and Albert family were behind the murder of John O'Keefe and that they've been running this town. So what about that factor here, that they could be afraid that there could be retribution? Not to mention, you've got, big bloggers out there who've been intimidating people as well. So what about this?
Yeah, I think you have a few factors at play. I think that's a fair factor in consideration, especially if those jurors out of, the 12 that are deliberating out of the 14 that were remaining live in or nearby Canton. That could be a concern. Also, if those holdouts for guilty are pro-cop, they may be thinking that John O'Keefe needs to have justice, which he does, but that also could be a motivating factor. And then I'll give another third opinion that perhaps the conspiracy theory, if my vote is a not guilty, then am I therefore giving credence to the whole conspiracy side, which they're not comfortable with? So I think there's a number of things that we can kind of land on that might be able to bring some understanding as to where some of the holdouts might be.
Mark Betterow, to you, it's an interesting point that was just brought up that I just saw. The foreperson in this case is a retired police officer, from what we're being told. Law enforcement officers typically are on the side of the law here, meaning that they would possibly support corrupt law enforcement officers. What about that, Mark Better? How,
you could flip that the other way and say, who's going to be most critical of bad cops, if that's what you're dealing with, other than good cops? The same way, ex-prosecutors tend to be very critical of, prosecutors they deem don't know what they're doing. So, I mean, look, both sides agreed to have this guy on the jury. So they must have known something. And I'm sure from the defense perspective, if they liked him, they thought, he may be receptive to, when he hears all this Proctor stuff, to say this is awful. I mean, they could be thinking, it's somebody like Todd. I know you've been critical of Proctor, and you get a good cop who's going to be just really not going to like a bad cop, and in a jury room hold some weight when they say, is this how you guys would do this? What do you think of all that? You just don't know. But I would think if their strategy is that, and they knew before the trial started, obviously, that all this Proctor evidence was going to come in, that, they thought they had some pretty good evidence of corruption, that a police officer who passed their voir dire test would be good for them. So now, is that the case? Who knows? But
you don't know. Chateau Lafitte
Joel,
here. Go ahead, Todd.
Joel, to piggyback on what Mark said, that aspect of, good cops, bad cops, there's without any type of confusion, we all heard the text from Trooper Proctor, but going beyond that bad conduct, the investigation itself had so many flaws in it, right from the beginning, from minute one. The poor crime scene, the poor collection of evidence, all those things. We can talk about some of the potential misconduct in the Sally Port, with the vehicle, inverted videos there was just so many flawed police procedures in this process. And again, take Proctor out of the conversation. There's so many other issues to point at. And so, again, we don't know what's in the mind of the jurors either way, but there was just so many things that they could have relied on to come up with an opinion, a strong opinion, as opposed to some of the more provocative matters that were present in this case.
Miss Little Bones here. By the way, Martin, I didn't give you a proper time to tell us your thoughts. Everyone else here who came on, let us know. Obviously, I don't even know what time it was. It was around 12 or 12:30 where the jury came back and essentially said that they were deadlocked to Judge Beverly Cannoni. Immediately, Adam Lally stands up and says they've got to deliberate. The defense appeared as though they would be okay with a hung jury. Was it surprising to you? What was your reaction the minute you heard this?
Well, it wasn't surprising to me because this is what I predicted. I, with a hung jury as a criminal defense attorney, maybe Sky will correct me if I'm wrong, but that's a win. It's a hung jury. It's a mistrial. The state's going to have to figure out whether they're going to want to try this case again. And I don't think they will. I really don't think they're going to want to try this case again after everything that's come out. And it's like, I think some of the panels already said, it's going to get worse. It's the feds are digging in. The more they dig, the more discovery the defense is going to have. And the feds may have really won the case, as we know. These biomechanical engineers, in my mind, that's what's won the case for the defense, and that came through the feds. Would they have hired their own biomechanical engineers, reconstructionists? Maybe, but these guys are just top of the top. So it's in my mind. After I was thinking about it, I don't believe they're going to try this case again if it's a hung jury. What I think, and again, this is going into my other profession of prophecy, that there's going to be an Allen instruction. I'm not sure if it was given already. I was a little bit out of it this morning.
It was not given.
Oh, it wasn't given yet? Oh, okay.
No, she said go back. Very generically.
Okay, well,
yeah, it
that's
wasn't
interesting.
great. Yeah,
that's interesting itself. I think it's only fair to give the Allen instruction before the weekend, give them another hour or two, and then let them come back before the weekend and say, we're done. And it's over. We're hung. Don't make us come back on Monday and waste some more time over this. I think that's what would be fair. Now, is the judge going to do that? That's her own call. Judges want verdicts. They don't want mistrials. So, okay, if the instruction hasn't been given, it's got to be given soon. I would imagine after lunch. I mean, that's what I would hope. I think that's what the defense would probably want. And when you have the weekend coming up and the jurors just want to get home and get done with the case, they just, they may just say, let's just wrap it up and finish. We're over this. We just can't come to a conclusion, and we're done talking to each other. So again, not surprising to me. And I guess only time will tell whether the jurors actually get to wrap the case up and then just give interviews.
Yeah. And Sky, I mean, to Martin's point just now, brother counsel, is it a poor reflection on judges when there's a hung jury? Do they take it personally? Do they want that verdict?
I mean, I think judges always want jurors to come to verdicts. They want closure. They want the case to be over. Nobody wants to do this again. But I don't know that there's any sort of reflection on the judge unless, there's been criticism of the judge and rulings that, may have skewed a case one way or the other. But I think like everybody, they want to be done, except for the defense, who would much prefer a mistrial to a guilty verdict. But I don't really think I could be wrong, but I've never had a judge take it personal or take it as a personal reflection on them. I think it's the province of the jurors to come to an agreement or decide that they absolutely cannot. And, that's well rooted in our system. And I think judges have a high degree of respect for that, or should.
If the case, Mark Betterow, if it is retried, this is a specific question, could they test the blood DNA on John O'Keefe's clothing to eliminate those in the house before proceeding to try and convict? These are all, interesting questions. We're far from this, but do you have an answer to it?
Well, I mean, they can do whatever they want to try to make either side to make the case better the second time around. The problem is just based on the evidence that came out in this case. If I recall correctly, the mixture of DNA that had the other two samples had insufficient DNA for testing. So if that's accurate, what are you testing? You're testing nothing. But if there is a retrial, I mean, if they develop other evidence, either side, good for them. The other problem they're going to have if there's a retrial is how are you ever going to get a jury, given that all the prospective juries have been watching every podcast, everything on TV, the screaming, the yelling online. I mean, it was bad enough before you picked the first jury, but that was about 10% of what you've seen in the last 2 months.
That's a great point. Well taken. It's going to be hard to seat an impartial jury in that neck of the woods. Todd McGee, another kind of human observation. Again, the minute I heard this, I scrambled to the studio, so I didn't see it with my own eyes. So correct me if I'm wrong, but according to reports, the O'Keefe family did not return to the courtroom for these instructions. Could that just be as simple as they were too far away to get back to court? Is there anything to read into that, in your opinion?
I wouldn't read into it. I'm sure things are fluid for everybody present, and just kind of the ebb and flow of how the day is going. We're in a space where anything can happen at this point. So I wouldn't read too much into it.
I mean, Todd, to you're the one person on here that has had to knock on doors with death notifications, which law enforcement says is the hardest thing that they ever have to do. What about, the person at the center of this? I feel like John O'Keefe, police officer John O'Keefe, that his name is always it comes up in passing. Just speak to what you think the family is going through, because this is agonizing for everyone, but it's got to be magnified times, a factor of a gazillion for the family.
Absolutely. We often stop and pause, rightfully so, to reflect on John O'Keefe, but we need to add the family members as well. They're the surviving members, and they're looking for that sense of closure. And right now, they don't have one, to be frank. So it is that the family factor is an absolute relevant one. And at this stage of the game, they've got a lot on the line, waiting in bated breath, I'm sure.
Brother counsel, it's no secret, guys like yourself, Mark Bettero and Sky Lazaro, you all drive fancy cars because your billable hours are pretty high. Ida Shaw, who's an attorney, does Karen Reed have the money to do it all over again? That's another problem. I've asked defense attorneys to take guesses at what Alan Jackson's getting paid. I know Tim Jansen said it's got to be in the $1 million range. No idea if that is true or not true. But what about the financial situation? I mean, they're well off financially. I think her father is a physician, but they're not, Warren Buffett and Jeff Bezos. How does that? I mean, it's kind of sad, but we see it all the time. Generally, poor people have worse representation. But what about a person like Karen Reed? Does she have the means for Alan Jackson for a second go around, or someone of his, his level of defense?
Well, first of all, I want to say that I drive a Honda Passport, so I'm not sure. I'm not sure if that's considered.
I knew you were coming back. I knew you were coming back with
that. I don't want to put Sky on the spot to see what she drives, but I just drive a Honda Passport with a car seat in the back. So
I bet you Sky drives like a pickup truck. I wouldn't be surprised. That or a Maserati.
I have a Porsche and a diesel truck.
Okay,
I was close with a truck. I was close.
When you give me a ride, I'll take one in the Porsche. But
come visit.
Maybe when Corey Richardson's case is going to be tried. Are you still an attorney on there?
No, she's not.
No.
Oh, okay. Well, I would say in terms of Karen Reed, even if she would run out of money, I don't know what her financial situation is, but I imagine that a GoFundMe would be funded within minutes for her because of how much support she has. So I'm not concerned in terms of whether she's going to have the money to be able to pay these attorneys. She's got so much support, and if the word gets out she doesn't have money, they'll just
I think there's already a defense fund in like the amount of. I'm not going to say.
Doesn't GoFundMe have policies against using GoFundMe for?
Okay, well, if you don't, I mean, if there's policies against GoFundMe, then there'll be other ways for her to collect money if she needs it to pay Alan Jackson. So, and Alan Jackson is, I mean, you'd have to assume for a high-profile attorney like that to take 9 weeks off of their life just to try the case. Forget about all the pre-trial work and preparation. He's getting a pretty penny out of this, that I can be sure of. So, but I'm not concerned. That's not a concern at all.
By the way, Alan Jackson's car is an airplane. But go ahead, brother counsel.
Yeah. Also, I just want to say one thing because I saw it coming up in the comments, and maybe not everybody understands what an Allen instruction is. So we're talking about it like everybody knows it. So an Allen instruction, just to quickly say, it's simply when the judge calls the jury in and says, let's keep open minds. Let's, let's keep deliberating. Let's not be stubborn. Let's be open to other possibilities. And that's, it's just basically her telling them again to keep an open mind and try to be workable and not be stubborn in your position. And then she sends them back, and that's basically it. Nothing too exciting there. But that's officially what has to happen before she rules that it's a mistrial. So.
Mark Betterow, to you, this is kind of an interesting question for you because you've been around jurors your whole life, but you've probably never been in a deliberation room unless you're a juror yourself. So since you've never been in there, tell us what happens in there. Joy wants to know, did jurors negotiate between themselves for an outcome? Never been a juror before. How does it work in there? Do they, the four-person take an initial vote and they go from there? Break it down for us.
Well, they don't, they're not really told how to deliberate, other than in any jurisdiction, they'll be instructed that the four-person, because somebody has to do it, will just kind of be leading the charge, but they shouldn't be given any greater weight as a juror, but that somebody has to start the discussion and somebody has to sign the notes and whatnot. Other than that, they're really not told anything other than just, be open-minded, be respectful of everyone's views. Don't deliberate if somebody leaves the room. Let them do what they want. The interesting thing here is during the judge's charge, before they started deliberating in this case, she specifically told them, don't take a straw poll in the beginning to see where you're sized up. Now, some juries may do that, some may not, but I've never heard a judge literally interject how they should deliberate. That bothered me, to be candid. Not that I care if they take a straw poll or not, but that to me does potentially make it a longer process. If they looked around the room after they go in there and just say, what does everybody think? And suppose, it's 10 people say, well, I think this, and there's 2 who don't, then they might say to the 2 people, what's bothering you? Like, let's talk about this. And that could steer a discussion. But if it's just kind of a free for all, and they've all got their notebooks that are filled with 2 months worth of God knows what, you just don't know what they're going to do. So there's no real right or wrong way for them to do it, as long as they're honest and open-minded and willing to listen and then reach a conclusion or not, as it may be.
Interesting question. Again, putting the cart a little bit ahead of the horse, but it's come up before. Sky Lazaro, can family friends who are basically named by the defense here, I guess otherwise, can they sue Karen Reed for wrongful death? Is that something that's a possibility down the road? And what would that entail? This is obviously a civil suit. We saw this with O.J.
Right.
Simpson.
Yes, and I think we see these in most of these cases. The burden of proof is much lower in a civil case. You're talking about a preponderance of the evidence, which is more likely than not 51% to 49%, however you want to kind of define it, versus in a criminal case where you're talking about beyond a reasonable doubt, which is the highest burden that we have. So I would expect, regardless of the outcome in this case, that the family probably will sue her. I've yet to be involved in a murder case that didn't involve a wrongful death. Suit after or during, depending on, when it's charged and statutes of limitations in different jurisdictions. So,
and that's like the burden of proof is totally different in a wrongful death case. Is that right, Sky? Can you explain that?
Yeah, that's correct. So I see them a lot in sex cases too. We saw it with, a bunch of athletes where, they either didn't file criminal charges or did. But then the victims came back and sued them in a civil context. So the preponderance of the evidence burden, essentially says, is it more likely than not that the person is liable? It's not a guilt or innocence, but is liable for the conduct. And if they are liable, what are those damages?
By the way, if you're disgusted and hate this coverage and hate all our best guests, please subscribe. And if you love it, please subscribe as well. If you're on the fence, please subscribe. And if you can't stand me, definitely subscribe.
And order Joel's book.
and order my. Thank you, Martin. I see. I never bring it up. Someone else brings it up. I do have an amazing book about my mom, child Holocaust survivor. Surviving the Survivor is the title. Go out there and buy it. It'll take your mind off of this Karen Reed stuff. At least the debate last night was very encouraging. Watching two men who are 197. I said two men. Sarah, to Mark Betterow, thoughts. This is out of my purview, out of my realm of understanding. Hung means some think she hit him, Mark, which also means they think she framed others for her crime. No way anyone who believes she hit him will acquit due to third-party defense, in my opinion. Please explain that and whether or not you agree with this.
Well, I think if the issue of whether she struck him with the vehicle and caused his death is the determinant fact to continue or not. I mean, if they consider that first, and if they all agree that the car accident didn't happen because of the ARCA witnesses and whatever, then you go home, because every single theory of every crime requires proving beyond a reasonable doubt that she mowed him down and left him for dead or killed him. So if there are people who clearly believe or can't get over that hurdle that the defense wants them to, then yeah, somebody thinks that she caused an injury to him by hitting him, which probably means they believe that that would have caused the taillight to explode and that it was not planted. And yeah, I mean, if there's one person, that's all it takes, who thinks that, then they could be sitting there. If there's 5 or 6 people, it could be anything. I mean, you just don't know. I mean, it's hard to predict what juries are going to do. I just don't think at any time, whether it's this jury or another one, I don't think you're ever going to get 12 people who are going to say that this case is proven beyond a reasonable doubt. I mean, we talked about this before, but it's going to only get better for the defense just for discovery reasons and other evidence and reshaping the case going forward. And I don't know how they're ever going to get 12 people to get past the technical experts and like Todd said earlier, as opposed to the, Trooper Paul theory of nonsense, which, call it what it is. It doesn't make any sense. And he was not a good witness. So if the DA gets out of this one with a hung jury, that's probably the best they're ever going to get. Political reasons factor in. Everyone else has discussed it. Perhaps they just say we did the best we could, walk away.
Todd McGee from there's a tweet here from Mary Louise Pinaz. If there is a hung jury, Trooper Michael Proctor could be fired before the new trial starts. What do you think of this, Todd? There's a lot of people asking, will he get his pink slip after this trial? I think it is probably not an if, but when. What do you think?
Well, I can tell you from the Department Rules and Regulations, Policy and Procedures, a Class A violation is a minimum of 30-day suspension all the way up to termination. So kind of the facts we know is he's part of the federal investigation. I shared earlier as we started to broadcast the show that removal of Trooper Proctor from the DA's office while this trial was going, politically, optically, was would be a very bad look for the prosecution. So better to kind of put him on timeout, let the case play itself out, and then internal decisions will be made afterwards. The next thing I can also tell you is that when the governor of Massachusetts weighs in on you specifically, in that she's disgusted as the former attorney general and governor of the state, that's not a good career move. So all those things, and I'll also add in, there are rules and regulations regarding telephone use. There's violation there. There's confidential rules and regulations. There's violation there. State police businesses to remain confidential. There's bias policing rule, policy and procedure. I could go on with probably 4 other potential violations that would be levied against him before a trial board. So everything remains to be seen, but I think right now politically is things are just kind of slow things down with the Trooper Proctor decision.
Yeah. By the way, reminder, we're doing a full recap at 4 o'clock. We've got the country's preeminent jury consultant Richard Gabriel from LA coming on, who was a jury consultant in the OJ trial, the Phil Spector trial, and the list goes on, along with Megan Sachs, who's a PhD in criminology, and at least one other attorney. I just wanted to clarify something here from Emily to you, Brother Counsel. And someone asked, who is that handsome guy in the bottom left? That is Brother Counsel. And that is the name of his YouTube channel. They want to know if he had a YouTube channel. Yes, he does. Check out Brother Counsel. Judge Bev didn't get the Allen charge yet. She told the jury to have a Snickers. But Brother Counsel, I think it was before you got on, I was reading a tweet from the prosecutor's podcast, and he was saying that the judge, I don't know if he meant literally or figuratively, instructs the jurors, telling them what a big case this is, how much it has cost taxpayers. Does that actually happen? Mark is shaking his head no.
No, that doesn't happen.
So Joe, that was a ridiculous summary, frankly, of what an Allen charge is. That is not what it is. It's a pet.
It's a pet. Okay, so
it's what I said it was a few minutes ago.
Yeah.
So
Hey,
well,
guys, I gotta jump off too.
Sky,
Sorry,
you're the best.
I gotta get on a call, but
Sky, they want to know, is that your horse next to you? I think I've asked you.
His name is Carlito.
Carlito, that's a good-looking horse.
Okay, so after the ride on the Porsche, we can go on the horse.
Yeah.
Sky, thank you so much. Have a great day.
Good to see y'all. Take care, guys.
Take care. Just a couple more minutes and we'll wrap up. So, I mean, that was the part. I didn't think so. The judge won't sit there and literally guilt these people over money, correct, Brother Counsel?
No, of course not. Yeah, no, of course not. There should be no other considerations besides the evidence, obviously. It's interesting that the judge doesn't want to give the Allen instruction yet. I don't know why she's not. She wants a verdict, and all judges do want verdicts. So I think if I was the defense, I would have said, well, Judge, I think it's appropriate to give the Allen instruction now.
They did.
Instead of, oh, they did say that? Okay.
They did, and she, it is the fourth day, but there was only a half day this day and a couple hours that. I mean, it really was they came looking for guidance. And to be honest, the judge just punted. It wasn't a great look. Nothing is resolved. You say the jurors are all hanging their heads, staring at the floor. It's Friday. It's a nice day. It's the summer. She's doing this in a terrible way. She should have given them the pep speech, and whatever happens, happens. Sometimes it works. Usually it doesn't, but she just kind of wasted more time in the nothingness that's happening right now.
I mean, I really feel it's only fair to the jurors to let them go after the weekend if they can't come to a verdict. I mean, I think that's only fair.
Did you say after the weekend, or would she give
before? No, be able to before the weekend. If they can't come to a verdict, let them go, and that's it. Don't make them come back on Monday, and then give the Allen instruction on Monday. They did their best. They've been spending how many hours, and as we know in this case, you're either one way or the other, and it's very difficult to convince one person, one way or the other. So I don't know. I think she should give it before the end of the weekend, and then if they can't come to a verdict, finish it off. That's it. Leave it as a mistrial.
Mark Betterow, your arch nemesis that you've never met. He's a good guy, actually. Jimmy McNutty. He says, even I will say Mark made a great point about. Do you feel humbled now?
I do, because we get along so well. Thank you. I appreciate the honesty in that. How can you think about all the publicity that's happened since the trial started, and these are the potential future jurors, and there's really prejudicial stuff. I mean, not that it's anyone's fault. You're just consuming discussion in media about it, but there are so many strong views. We're all responsible in some part for that, as well as 20,000 other people all ranting and raving about what the evidence is, or how could you not believe this or believe that. The thing that just surprises me with the jury is when those accident reconstruction people testified and they were asked, well, you didn't look at the taillight or this or that. And their response was, no, I didn't, but I didn't need to, because I'm using mathematical and scientific formula. And I'm telling you the cracked taillight means nothing to me because it couldn't have happened this way. And I think by definition, if you accept that, then that means, well, how did that taillight get on the lawn? And now you start going down that rabbit hole the defense wants you to go down, which is it got there somehow. And I'm kind of surprised that if you accept science from real scientists, I mean, these are not amateurs. These are real guys that there's at least one person who's hung up on something. It's surprising to me because those guys were pretty compelling, I thought, and had degrees longer than all of our arms.
By the way, a huge shout out to the COE, Space Coast on the West Coast, Steve Cohen, everyone's hustling behind the scenes, and of course the mods. There is always chaos when we're talking about the trial. They're keeping everyone in check, and Space Coast is definitely working hard today, dealing with that. One other thing, then we'll get final thoughts until we resume back at 4 o'clock. One of the things that came up here is an Alford plea, brother counsel. Can you explain that, if that is even a remote possibility here, where they would allow Karen Reed to offer some sort of Alford plea and then just move on from this completely?
No, I don't see any of that. It's going to be a hung jury, or it's going to be a verdict. There's nothing else happening in this case.
Nothing else. Here's another. After watching the debate last night, have you shifted your thought process, Mark Betterow? Are you considering a run for the White House?
No, after watching last night, before that, I'm considering moving to Toronto. It's a more likely option after watching that last night. That was disturbing on many levels for a lot of different reasons, no matter what your politics are.
Yeah. Let me tell you, no matter what your politics are, everyone should be very concerned about what we saw last night in a major way. The only person I know who actually lived up to it is my uncle, who's a hippie from the 1960s, who went on to become, he's one of the guys that helped eradicate smallpox, and one of the people that Anthony Fauci was calling during the pandemic. My uncle is a pretty famous guy in the field of public health. Shout out to Uncle Ron, who, when he saw what was going on politically in his country, he bought a farm in Portugal with his dog, and that's where he lives, and he's living a good life. So kudos to him, and
Joel,
haven't heard from him in a while. Yes, sir, Todd McGee.
I heard someone sum up someone summed up last night's debate very nicely with 5 words: hell no and oh no.
The idea of two 80-year-old something men arguing over who has a better golf handicap,
They need to have a golf off for the. I thought there's a comic named Joe List. I don't know much about, but I do love stand-up comics. And again, this is not for one side or the other. This is comedy. It was a photo. I mean, it was a screenshot of Joe Biden just looking like a deer in headlights. And in the bottom corner was the live bug that says, live. It just said live. But he said that's what Joe Biden is trying to do during this debate, inferring that he was just trying to live. And I thought it was hilarious. And I tweeted it out. I'm sure people yelled at me. But anyway, I figured I'd end on a note that will get me in trouble with everyone. Final quick thoughts. Todd McGee, you're the voice of reason. How does this end now? Are they going to come back, say that they're deadlocked, and are they going to be sent home with a hung jury and a mistrial in this case, Todd?
I think that's the play where we're at, Joel. I think we're back in here again, front half of next week, July 4th, looming in the background. Is that a motivational factor? Maybe, maybe not. But again, we got less than 2 hours left in the day. So unless someone wants to go home early, we saw that this week as well. So I don't see the needle moving any further than it has already this afternoon.
Mark Betterow, veteran criminal defense attorney, your final thoughts here.
I'm not dismissing a verdict, although certainly the likelihood of a hung jury seems much greater now than I would have thought yesterday. But if we're reading tea leaves and speculating, I think there's a possibility there could still be an acquittal. I think it's a lot less likely than I thought originally. I can't see it ever being a conviction no matter what. But if it is one or two people who are just stuck on the scientific argument, I don't exclude the possibility that with more work, it could get done. But so at this point, certainly a hung jury seems like, if you were a betting person, has increased a lot. And a conviction, I think, would be pretty much off the table, and still a possibility of an acquittal, but less than there might have been, we all thought, a day or two ago.
Marco with a great point here. Poor Joel, his mother's a Holocaust survivor, probably has the most harrowing lessons to share. Buy my book, Surviving the Survivor. An uncle who helped eradicate All he does is peddle his book. That's all he does. He just peddles his book, and all he wants is clicks. Secret, we do want clicks. An uncle who helped eradicate smallpox. And Joel, what does he do? He listens to us public nut jobs. That's why I have a shirt. I love you, public nut jobs, but I have a shirt that says Black Sheep. I'm the only non-doctor in my family, and I've got a chip on my shoulder. Trust me. Martin Radner, brother counsel, a smarter man than I, who lives in Detroit and the greater Detroit metropolitan area. Are you going to be right? Are they going to come back in an hour or two and say we're still hopelessly deadlocked? And is the judge going to say we're done? Smack or gavel down, hung jury, mistrial, it's all over. What say you, Martin? How does this end?
Well, that was my prediction yesterday, and that's going to stay my prediction today. It's probably going to be a hung jury, which is, again, another reason why everyone should, of course, subscribe to Brother Counsel. You stay a step ahead of the game when you watch the content. So, yeah, I assume it's going to remain hung. I don't see a not guilty verdict. I never saw a not guilty verdict, as much as I believe it should be a not guilty verdict. But most probably, I'm going to stay with my initial convictions that it's going to be a hung jury.
Yeah, by the way, I'm monitoring Twitter. It looks like there's some tension that's building outside that courthouse. We might have to send Todd McGee out there, retired Mass State Trooper, to keep people in check. I cannot thank these best guests enough. Mark Betterow, criminal defense attorney, brother counsel's got the YouTube channel. Todd McGee, retired Mass State Trooper. Sky Lazaro, Josh Ritter, who are both here. Amazing to have these people in our community as our best guests. Thank you, everybody. We're back for a full show with a veteran jury consultant in exactly an hour, and I'm bad at math, 38 minutes. We will see you at 4 p.m. Eastern. Until then, love you, America. Love you, Canton, Mass. Justice for John O'Keefe.